All right. Good afternoon, everyone. This is Kurt Varone,
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup for November 13th of 2023.
And I just want to start this off by saying this is probably my favorite group of issues. I can't say cases necessarily because of the first one, but of issues we've ever done as a collection. This, if you guys are watching today, right, grab some popcorn because I think this is the greatest accumulation of cases we've done for very, very interesting stuff, has some great learning lessons. You should all get credit for watching. But this is important. So let's start off in Pennsylvania. Or I'm sorry, Louisiana. Not Pennsylvania. Louisiana. Sorry.
Yeah.
What's that? So what we're going to talk about today, what the Office of the Inspector General in Jefferson Parish, Louisiana has found is a nationwide issue. Kurt and I speak about some of these issues all the time, but what happened, what they found in Jefferson Parish, Louisiana, the Inspector General did a report, and the OIG, Office of the Inspector General, OIG found that there's about $28 million of questionable spending by volunteer fire companies, including $8.5 million that the OIG concluded was just misspent. And this is a 10-year study between 13 and 23. They recommend some changes. And I want to tell everybody here, right? If you haven't seen Kurt and I screaming about some of this stuff, you haven't been paying attention. But this goes a little farther, and none of this is uncommon. We just spent, I obviously won't say who, but we just spent, my office spent some time reviewing the financials, which we do all the time, of a fire company. And it was shocking, well, not shocking, unfortunately, to see what places spend money on. So let me start with this point before I go through what the OIG found specifically, because none of this is shocking, right? But we have to keep the public's trust, whether you're a fire department, whether you're not. And you're going to hear that theme, public's trust, throughout this video today, because we're going to discuss another part which talks about the public's trust in a very different context. But here, the OIG pointed out things that are very common, right? So they started with, in this 23-page summary report, talks about financial irregularities. And they say that there are financial irregularities because there's a lack of accountability by the fire companies. Now, I think that's true, but I have to tell you, the question we should start with is, who are we trying to be accountable to? And I think most of the fire companies, and don't get mad at me for attacking you, because, right, if you're getting upset, you're probably one of the people with, or one of the departments with problems, right? If you're not upset, you're like, yeah, so what? So, the accountability we need to have is not to the fire company itself. Yes, that's part of it. But the accountability we need to have is to the public. So we have this attitude in the fire service that we want the public out of our finances. It's not their business. But it is, right? And if not legally, certainly as a matter of practicality, the public needs to trust us. And they're giving their tax money to us, and we then go and spend it on things. So the OIG's report looks at the things we spent it on and said, look, we're paying bonuses, right? Now, they may or may not be right on paying bonuses. A municipality can't pay a bonus because it's what's called an unconstitutional gift of public funds. A private company could, but, and then there's some other things. Now, I want you to say that some of this isn't like, oh my God, how could they do that, right? But you have to understand it from the public's perception. So, for example, use public funds to purchase flowers and pay for parties. Well, we call that respect, and we call that, sunshine funds, right? We're taking care of those of us who are sick. So that may be the flowers things or congratulations, right? But it's showing that the fire company cares. But in the public's mind, that's not the case, right? In the public's mind here, they're saying, how can you buy flowers, right? We want you to buy hoses, not flowers.
Brad, I want to before we go too far, because I want folks to understand what's going on in this organization, because I think sometimes when career firefighters hear the term volunteer fire company, they'll roll their eyes, oh boy, and just hit fast forward, and they're not going to listen to this. And that's a mistake. These are by and large career departments. They're overseen. They're basically, the employer is a volunteer fire company. And I'm sure at one time, each of these 12 entities was fully volunteer. They are no longer.
The name still says volunteer.
Right. And if you look at the report, they have the total number of career personnel and volunteers. 4 of them don't have any volunteers. So basically, you have a volunteer fire company that has no volunteers. Okay,
right. So and that makes a big difference here.
Well, right? It does, but I think the principle that we're talking about goes beyond just volunteers and volunteer fire companies.
Very good point.
It goes to our credibility in the public's eye, and the public at the end of the day controls the purse strings. Yes, through elected officials, but at the end of the day, and when they lose confidence in us, then we've got a bigger problem, because then when we really need a new truck, or we really need to replace hose or SCBA or whatever it is, we're going to have a problem with our messaging.
Right.
And that can be fatal to some organizations.
But here I don't know, because there are too many generalities. Were they saying, well, you have no volunteers, but you're buying flowers and having parties, right?
Yeah, no, they didn't say that. That it was just that money was being misspent. It was public funds being spent on things like bonuses, and flowers and parties, but
food and restaurants. And
when you think about a volunteer fire company, historically, they were not funded through taxpayer money. They were funded through donations and ham and bean suppers, and you know what I'm saying, pancake breakfasts, and that's how they were funded back in the early 1900s. Well, you can't buy $1 million engine with bake sales, and we realize that. So now a lot of the practices, obviously the funding mechanisms have changed, but the thinking that it's our money and we can do what we want, and we can give the middle finger to the elected officials and anybody who doesn't like the way we spend it. Now that kind of mindset is problematic. And I think that's one of the big messages here.
But if I'm a true volunteer fire company watching this, I'm saying, wait a minute, we can't buy flowers and parties and go to restaurants and food. And I want to go through the rest of the list, but the answer is you can, but you have to understand the public's view, and it has to relate to recruitment, retention, not, hey, let's just go out for dinner, on the company's fund here, right? There has to be some direct tie to recruitment, retention, or the volunteer fire service or whatever. For example, right? So the OIG didn't like that the fire company spent money on food. Here's my thing. I would pay for every single meal of a volunteer firefighter or EMT if they're in the station. If they're in the station during lunchtime, staffing the station, I would say support putting food in the station. If that's what it takes to get a volunteer there, then do it. So the OIG may have a very different view. I'm not defending or attacking the OIG, but what I am saying is we better look at this from the public's viewpoint and be able to defend it. If it's just, hey, anyone who wants to go out to a restaurant on us for no reason whatsoever, take the money and go, well, that's different than we stock the refrigerator so people will come and stay at the station, right? But there's other things they went through. So, and I dispute for a lot of reasons, but they say, like, use public funds for non-employee expenditures like cell phones. Now that could be some ignorance, because as we all know, companies like, I Am Responding and a bunch of other apps, right, our cell phone now is a tool. This is a tool. This is like our pager. Tells us how to get to the call, where the hydrants are, right, notifies us of the call.
And it gives us access to pre-fire information.
Yeah, pre-planned.
In our database, yeah.
Right, and normal internal communications. I mean, so many things. Our phone is the pager of the 21st century, right? So I don't know when they say cell phones here, well, was it legit or not? Or was it the secretary and the treasurer who are volunteers who needed a cell phone, or the president of the board of directors? I don't know. But, there are, now when we transition to other things, for example, wasted public funds on late fees. I agree. Late fees, or things like I see all the time, sales taxes being paid, right? You can't do that. But this report is a report that nationwide we should be, because these issues are not about this parish in Louisiana, right? And the reason you put this up, obviously, is because these are widespread nation issues. But if you're upset about some of these, how can they say you can't pay money on some of these? Well, the answer is you may not be wrong spending money on some of these. On the other hand, you have to look at the public's perception and explain why you're doing it. Like the food, like the cell phone. It can all be seen in multiple ways. There was one weird one though. That one of the parishes paid $5,600,000 to a non-existent entity, which is then transferred to a volunteer fire company. That one shocked me a little bit.
That kind of threw me. And this is a 23-page summary of what I assume is a much more in-depth investigative report that probably is not going to be released. It's probably an exception to the public records law, but that would probably have the details of that. But that certainly caught my eye as well.
Right. But I'll guess I'll end this one by saying departments need to bring in an outsider, like you or me. I'll be self-serving here, but like you or me, and needs to go through the books and the expenditures. And I have a company that does this, right? Fire Service Financials. And this is why we do that, because you need to be looking at your expenses, both from a professional's view, whether certain expenditures are appropriate or not, and you need to be doing it from the public's point of view, so that when you're asked, you can either defend it or you can say that we stopped doing that, one or the other. But it's very difficult to have your own insiders who are benefiting from this money come in and review your own expenditures in your books. You're not unbiased. So I am encouraging the volunteer fire service, and look here, if you're an employee, right, a total employee-based organization now, your same organization, to bring someone and conduct, it's not an audit, right? It's not a CPA's audit, because they look at different things. It's really an appropriate, a review to determine if the expenditures are appropriate, proper, et cetera. Because the OIG goes on and says that a lot of this is because there's not proper training for directors and officers. And I will say, like my firm, we just held a training, a board of director training. The room was packed. We had to cancel it. We had 80 people there, and we didn't expect that great of outcome, which is good, but it just shows this type of training is needed. And you and I, frankly, need to be doing this training throughout the nation. I will tell you, if you're a fire company, we should look at we have an upcoming bylaw session, which they should look at your website for. And what's the date of that again? Do you remember?
November 30th, I think. Yeah.
Yeah. So
that's an evening webinar too. Folks just looking at it may miss that, but it's going to be at 7:00 at night Eastern. So.
Right. And the topics we'll discuss there will go towards the comments that we don't have proper training and understand the law, but people do need to start getting training on their responsibilities as directors and officers of a not-for-profit corporation. And that will go a long way to help. So.
Absolutely. And yeah, I think another big theme that I took out of this, the fire protection in this county or parish should not be delivered by volunteer fire companies. They're past that. They should be consolidating and becoming municipal departments. Because of the amount of career personnel that they've got. And when you get into a municipality, most municipalities already have these financial control systems built in, whereas the volunteer fire companies don't. They've got to rely on their bylaws and a lot of the other things, which it's not impossible for a volunteer fire company to put them in. And I think your bylaws training is going to get to that. But the once you go to a municipality, you're under state law requirements for purchasing and so on, ethics and some other things that are, going to kind of take care of themselves once you're a municipality.
And of course, the volunteers. And look, as everyone hopefully knows, Kurt and I are volunteers, right? We're not attacking volunteers. We have decades of volunteer experience, but this is just the reality of money's getting tighter. The public's getting smarter. The public is looking, and what we got away with before isn't going to fly, whether it's intentional or just bad management. You need to start looking at your operations.
Yeah.
Let's go a little bit down my street to Buffalo, New York. And I'm gonna, before I get into this, this is very, cutting edge in the sense of just happened. But before I get into this, let me just comment. Hey, I live in New York. Don't come firebomb my house. But I'm not attacking anybody. If you watch last week's episode, this is going to relate to some of the topics we talked about with the firefighters rule and such. And the week before, I think too. But I have a lot of questions about this suit, so I just want to raise the issues. I'm not trying to attack the widow in any way. Please, we're only discussing the legal issues about this. So here in Buffalo, we have a line of duty death on March 1st of 23. The widow is now suing and sued the contractor, which I think is very interesting, the city of Buffalo itself, and they're accusing them of negligence and wrongful death. I want to go through the allegations a little bit, and then you and I can kind of jump in with our defenses, because my bet is this gets dismissed.
Yeah, I didn't include, at least in the write-up, I didn't include a lot of the allegations against, I didn't include any of the allegations against the contractor or the building owner. I really focused more on the department. But if people go on, and this is something that it frustrates me sometimes, where people only read the headline. They don't read the whole story. And you can't just read the headline. You can't just read the post. Go on and read the complaint, and you'll get a lot more out of it. And that's going to be a theme that we see in several of the other stories this week as well. You got to go beyond the headlines. But I focused on the post, on the allegations against the fire department, because I think that it's really important that chiefs out there think this through. And if I'm the chief of a department, how am I going to defend myself if we have a line of duty death and these allegations are made against me? Can I refute that? Do I have the documentation that is going to refute each of these allegations?
And we have the court of public opinion, which I think is the only place, frankly, where the widow wins here. But we also have the court of law. So here what happened is, when you read the lawsuit, it is basically just a recitation of 1910-126, the fire brigade standard, which in New York, by a case called Ballston Spa, the New York court said, look, the fire brigade rule, a federal standard, federal regulations, is applicable to both paid and volunteer fire departments in New York State. So here we have a paid department, City of Buffalo, but it claims that the city failed to basically comply with the entire fire brigade standard, right down to the 2 in, 2 out rule, which I was really shocked about, but nonetheless, they just took the whole fire brigade standard and said, these are all the things you did wrong. So basically they're alleging negligent supervision, negligent training. The problem we have here is in New York State, like most other states, you can't sue your employer. So, and I'll throw out a possibility here, but you can't sue your employer. So how do you get around that? In a case
you can't sue in tort.
Right.
Okay. So that's where a lot of times in a case like this, we'll see constitutional claims, due process violations, and so on. But you can't sue in tort for
meaning negligence.
You can sue your employer in tort due to workers' comp exclusivity.
And here, that's what they're doing. They're saying our employer was negligent or failed to, adhere to all these federal standards. The problem is you can't sue based on that. However, and that's not what I'm going to say is not alleged here, but in many, many years ago, my department and neighboring departments was sued for a line of duty death. And I said, there is no chance it's going to win. Except the appellate court came out, and I wrote an article in Fire Engineering, and you and I and a million others have discussed this, and the article's still floating around out there, and just interestingly enough. But the rule in New York State, you can't sue your employer, right? Then it is pretty much absolute. If you can find someone else to sue, like the contractor, building owner, maybe, and I still want to talk about them anyway. But one way you get around this is you find somebody else other than your employer to sue for it. Here, it's the City of Buffalo. I don't know how you're going to do that. And most of these failure to comply with federal law, they don't win the day, right? Yes, you failed to comply with federal law, and OSHA may come in and tell you, or New York State PASH, but state OSHA, but they may come in and say you didn't do things right. Now, there's a federal law nobody ever thinks about, won't come into play here, but is NIMS. And everyone's like, well, why would you bring up NIMS? Well, because NIMS has certain standards which are also mandated by law. One of them that could be applicable here is the incident command system. You have to check in, you can't freelance, right? It's hard to tell exactly what specifically they say caused this death, but on the part of the fire department. But even there, if you cite federal standards, you can't do it against your own employer. So that case that I'm citing, where they use NIMS and whatever, it still recognizes you can't raise federal standards against your own employer. It doesn't work to get around the workers' comp rule. So I don't think this survives a motion to dismiss with the city of Buffalo. And I'm a little shocked. I even looked at the law firm to see, if they do this kind of stuff. I'm a little shocked that they are suing the city, because I'm going to be curious how you win. But the contractor is a different issue, except for something you said last week. So unless you want to talk about the city, let's talk about the contractor for a second.
Yeah, well, I think before you get to that,
yeah.
kind of jumping around here, but I think there's a strategic issue trying to get my mind, in line with what their attorney, the attorney who represented the widow, do we go after the contractor and the building owner, or do we just go after the fire department? And what happens here is when you make allegations against both of them, they're both going to be pointing the finger at each other. And I think sometimes you have a strategic decision. Are we better off just going after the contractor and just focusing on their negligence? And then if they want to bring the fire department in, they can bring the fire department in. Or do we bring in the fire department, just go after the fire department? In both of these cases, if you're going after the contractor and the property owner, we're dealing with the fireman's rule that we talked about last week.
Yeah.
Okay. So that's sort of issue number one. If you go after the fire department, you've got this workers' comp exclusivity, possibly sovereign immunity, and so on. So you've got some other defenses over there. And so there's a strategic, their option was to do, I think the typical, what they expect on a law school exam is you go after everybody. And that's what they did. They went after everybody. But now you give them the opportunity to point the fingers. Besides their individual defenses, they'll be pointing the finger saying, well, if the fire department, the building owner is going to say, if the fire department had their act together, this wouldn't have happened. They're the proximate cause. And the fire department's going to say, no, if they hadn't started the fire or they maintained the building properly, even if we were an awful fire, which Buffalo isn't an awful fire department, but if they were to allege that, if the building didn't catch fire or the building was properly maintained, our guy wouldn't have died as well. So now it just turns into this big mess.
But I'll tell you why that's a horrible idea.
Yeah.
Because think what's going to happen if let's assume City of Buffalo gets out of this.
Yeah.
Right. Because I think that's what's going to happen. But you're in front of the jury now on the contractor. Now, I think they're going to get rid of the contractor too. Well, but we'll talk about that in a second. But now assume for a moment the contractor's there, because you always have to think of your case from day one. You have to think of day end, meaning what's the last day you're presenting in front of a jury. And if it's me, they just raised the plaintiff. And I think they made a fatal mistake in front of a jury. The plaintiff just said, hey, guys, look at all the things the fire department did wrong. And now what they did is they just cut the legs out of the contractor, because the contractor, even if the contractor is found liable, and I'm sorry, they cut their legs off of their case against the contractor, because even if the contractor is liable, they can now apportion liability to the city saying, yeah, but had you done all these things, you would have only been 10% liable or whatever. So I think this was a horrible jury mistake. They're going to divert the jury's attention to the city where they couldn't have won in the first place.
Yeah, it'll be interesting. And I think the point, I kind of jumped around and I cut you off when we're going to talk about the fireman's rule and the general fireman's rule. If you want to talk about it, the general rule is that when you're a firefighter and you go to an emergency, you can't sue anyone. That's sort of the general rule. Then we have all these slice and dice exceptions that different states have. Some states say you can't sue the person who caused the fire, but you can sue anybody else. And then there's some that say you can't sue the property owner of the property that caught fire, but you could sue the person who caused it if they were not the property owner. And all these different exceptions. Somebody could write a book just on the fireman's rule.
Yeah, and the Black Sunday cases review a lot of that, where they're trying to hold the apartment owner and contractors all liable criminally and civilly for the Black Sunday deaths.
Yeah. So, at the end of the day, and I don't know if you're ready to kind of speak on New York's take on that, but I'm interested to hear, because I'm not up on each of the specifics of each state's interpretation of the fireman's rule. So where do we stand on that?
They're losing in the fireman's rule.
Oh, really?
We could pull up, if I was better prepared, I would pull up the Black Sunday cases where they tried this exact thing. But look, in New York and many other states, right? It's one thing and we talked about this last week. So let's talk more generally. Even, what we said last week was, as you're saying here, it's one thing where the property owner leaves their property in a dangerous situation such that after the fire department responds, they encounter a dangerous situation, just like, ice on the driveway, or in the case we did, there's no drywall and the studs are missing to prevent someone to go over a staircase, right? So let's say where there's a hole in the floor that, a firefighter shouldn't have expected there to be just a gaping hole, not from the fire, right? But just there's a hole in the floor. So where a property owner creates a dangerous condition that injures somebody, regardless of whether there would have been a fire there or not, right? The property was just in a dangerous state. You could sue. But here, I think what they're saying against the contractor, I'll be a little cautious, is basically they caused the events that caused the fire. I don't think, right? And Black Sunday was a little different, because they're saying, well, they carved up the building in such a manner and didn't comply with code and all these criminal and civil violations. And because the building was cut up, that's what caused the firefighters to become,
and in Black Sunday, they were going under a statutory violation, not necessarily tort negligence. They were saying you violated a statute which provides for a remedy for statutory violation, which arguably is an exception to the fireman's rule.
Yeah, and right, and they tried civil penalties, not a lawsuit. Well, they had tried lawsuits too, right? But in any event, here the short answer is you are generally not going to win against a building owner and maybe even a contractor based on something that caused the fire, right? If they created a dangerous condition that if you invited a guest over, right, which is what you're doing when the fire department comes, they're called an invitee. It's like you're inviting a guest and they get hurt because of your property condition, not because it's on fire, but because there's something that's happening in your property, like a gaping hole in the floor that shouldn't have been there, then you could be liable for that. And that's the New York rule, but that's many rules are similar to that. And I just don't think they're going to win as against the building owner. Now, the contractor is different, but there you still have no duty. The contractor owes the fire department and the firefighter no duty necessarily. The landowner does a duty to maintain a safe environment. I don't know that suing the contractor is okay, but look,
the contractor started the fire. That's the problem. The contractor, it wasn't the contractor, miswired an electrical outlet that started the fire. They were using a propane torch that in turn started the fire.
And there's no liability for that. I mean, that's the fireman's rule. That's the whole point of it, right?
Well, yes and no. And again, every state's going to be a little bit different. I will tell you that there was a case about 10 years ago out of Buffalo also. Different fact pattern, but two firefighters get killed. They both sued. I was in touch with their attorney, and they both sued. They both got $1 million settlements against the city. They did. That's right. They did go after the building owner. I don't recall off the top of my head if they got a recovery from the building owner. And the reason I say that is in that lawsuit, one of the themes that they alleged was that the building owners were on the scene at the fire, which you notice that the complaint alleges that both the contractor and the building owner were at the scene or close by. But they were at the scene, and they failed to warn the firefighters of a dangerous condition that was in the building.
Different issue.
I gotcha. But the plaintiff's attorney put that in the complaint and kind of teed up that issue. Maybe to survive a motion for summary judgment. Maybe it's going to be their main. Maybe it's going to be their main, avenue, their main strategy. But they want to get the duty to warn about a dangerous condition, and then the failure to alert them. And they made a couple of allegations in there. And again, I don't know what happened. I don't know all the details, but they made a point of saying that this firefighter had a radio and had the incident commander, had the building owner told, or the contractor told the incident commander that such and such happened, that he could have been in communication with the firefighter and warned him, and that did not happen. So,
and it's funny because here they talk about the 2 in, 2 out rule, right? Which says you have to be in visual and voice communication. And well, look, when you put water on a fire, there's no more visual, especially in a big building. So the question is, did they have voice communication? And that tees up another interesting issue that, okay, let's assume the contractor did tell or would have told. Would that have even mattered? Could they have had radio communications? We've seen other radio communication failure cases where
absolutely. Well, radio, once you lose comms with an interior crew, there's two parts of accountability. But once the incident commander or the division sector officer loses comms with the interior crew, you've got a 2 in, 2 out violation. Period. It's clear. Okay. But what happened here was the two in team separated, and the officer got away, and it kind of made it sound like it was an acting officer and he wasn't properly trained. And I don't know if that's true or not, but point being that this guy's buddy got out and he did not, and that could be a 2 in, 2 out violation as well, because now you've got a crew that's separated. So again, a lot of factual questions here. Yeah.
So look, we feel for everybody, obviously, on a duty death, and you want to, it's a dangerous job we do, right? So it's, my
take on this is I would encourage everybody to read that list of bullet points that I've got there. Those are the allegations that you screwed up. Now, whether or not they can prove it, whether or not they are going to be defenses the city has, but I think I put them there. The reason I put them there is because I think that in the event you have a line of duty death, these are the allegations that you're going to be facing. And what you want to be able to do is say, okay, I'm going to be able to refute that with training records. I'm going to be able to refute that with our policy that prohibits that. Not only having the policy, but here's several reprimands that we've given to officers for not adhering to the accountability policy. Because if you've got an accountability policy and it's been in place for 20 years and no one's ever been disciplined for it, I'm not saying fire somebody, I'm not saying suspend somebody, but I'm saying document that you hold people to it. Because many departments that I go into, and sometimes I have to go into review problems that happen, and I talk to folks and they're not anywhere near pretending to be compliant with 2 in, 2 out. They don't even pretend. But then when I ask the chief, I put the chief on the witness stand, the chief, oh yes, we comply. I'm like, it's disingenuous. Okay. So you've got to be able to show that you're actually enforcing your accountability procedure.
Agreed. Okay. So, again, not to dampen anyone's day, whether it's the plaintiff or the city. And look, this looks bad for the city regardless.
we don't spread cheer.
No. Maybe our Christmas show will spread goodwill and cheer and love for all. But okay. So, but again, nobody should ever take Kurt or my comments as anything other than we're commenting on the law, not and as it relates to those alleged facts. So,
and certainly not on the facts. And this next case really points that out. By the way,
I hope you have more information than I do. So let's go to Illinois. There's a couple of these out there, these situations that happen. I speak to one of them, but a lot. But so here we have a husband is suing, a husband of an Illinois firefighter was suing The firefighter was allegedly, let's say allegedly, but bullied and harassed allegedly by a lieutenant, as well as maybe some others. She took her own life. And I'm going to read the note she left. I believe that was from her note, right? And she wrote, this is her suicide note, and says, "Work has destroyed me. I cannot take one more single day. Almost everyone at work will be relieved. And P.S. You're welcome, Lieutenant. I'm gone. I'm no longer your problem. You win." So there was a lawsuit. Now I'm a little sickened by some of this. Well, by all of it, obviously bullying, harassment allegations. But what gets me is there's trial or something, or discovery proceedings, which is where we request documents. And after discovery, the village moves for sanctions against the husband of the firefighter who took her life for filing a frivolous lawsuit. They then, and I don't think they settle it, I think he agrees to withdraw and, to a dismissal of this.
Right.
So this is the part I don't understand. What did they discover? Do you know? Because this doesn't sound like anyone was making it up, but yet.
No, my guess is, well, let's start with what happens when somebody suffers a loss. Okay. And they feel hurt, and it's almost like a human nature thing. We're looking for people to blame. And many times people go to an attorney and they feel that they've been wronged, and they feel that it's obvious and so on. And then as you start to get into it, other things come into play. And I don't know, I don't even want to speculate as to what those may be in this case. But a year goes by, you look at people's medical records, you look at witness statements, you interview witnesses, you look at maybe some documentation, you look at people's past, their history, their medical history, and so on. And it becomes obvious that what maybe you thought you were going to either, number one, you thought happened. Number one, you thought something happened, and now it appears it didn't. Or you thought you were going to be able to prove something, and now, even though you think it actually happened, you can't prove it. One of those two things, I think, is in play here. I don't know which. I know a number of people reach out to me after I posted this saying, how could this happen? Did the city bully them into settling? And I don't think it's necessarily bullying them into settling. I think that you either are able to make your case after discovery, you're either able to make your case or you're not. And it looks like whatever they thought they were going to be able to prove, they're not going to be able to prove. And, we can speculate. I don't think it's healthy. I don't think it's appropriate for us to speculate as to what those things may have been. At the end of the day, the plaintiff's attorney and legal and the plaintiff himself made a decision that it's in their best interest to withdraw the complaint. And in lieu of them withdrawing the complaint, I'm assuming the city has said we will waive any sort of sanction request. But if you don't, if you continue to pursue it after knowing what you know now, if you continue to pursue it and we win, we will seek sanctions against you.
Now,
and that's not uncommon, it's not uncommon for that kind of conversation. It's not a fun conversation. I've been on both sides of it. It's not fun, but it's get real time in terms of not necessarily what happened, but what you're going to be able to prove.
Right. And I'll tell you what, go back to April of 2016. And strangely, you have almost the identical case with a different outcome. Nicole Mittendorf. Yeah. Nicole Mittendorf was bullied as I think she was a lieutenant in her fire department. She was bullied to the point of trauma, mental trauma. She sues and wins, and despite winning, takes her own life. And I think, as I recall, this is going back a little ways, but as I recall in the Nicole Mittendorf case or issue, they wouldn't release the suicide note. I think the husband kept it confidential, but they had already won the lawsuit, and then she takes her life. Here, this Nicole, different Nicole, took her life, right, before the lawsuit. So, but
yeah, there's been a couple. I don't recall all of the details. And I remember the Nicole Mittendorf case. I remember very similar. Her husband was a firefighter in the same organization. In this case, it was in the same organization. I'm not sure the status of her litigation. So, but
yeah, and the reason I bring her case up, because she did take her life and she was bullied, right? And she won her lawsuit. But I just don't want any would-be bullies in the fire service to think, oh, we're going to get away with it. We don't know what happened here that was discovered that led to this, but nobody should take away from this that harassing anyone, bullying anyone, hazing anyone, cyberbullying, whatever it is going to go unpunished. Because if it's true and it truly happens, and I'm not saying it did or didn't happen here, I have no idea what happened here. I'm totally confused. But you are going to lose a suit. And forget the lawsuit. If you harass and bully and haze someone to the point of suicide, frankly, you should go to jail. And some states have those cyberbullying laws that do that. So anyway, I sorry.
I feel strongly about it as well. I think we both feel very strongly about people who bully others. My concern is that I have yet to meet a bully who knows that they're a bully.
Yeah. Yeah.
That they think they're just a normal person. They're not picking on anybody. They're just having fun, or they're just doing this or just doing that. They don't realize that they're bullies. And so we're kind of speaking to, when we say to the bullies out there, nobody out there identifies themselves as being a bully. They all feel that they're doing it and they're justified in doing whatever they're doing. They feel justified in doing it. And that's what makes it difficult to deal with bullies.
And if we were giving, and we've done this before, I think in my conference, hazing and bullying lecture, what I would probably do is pull up the last couple of minutes of A Few Good Men, right, with Tom Cruise and Demi Moore, and I would pull up the Marines, and he keeps saying, I don't get it. We won. We just followed order. We just followed orders. We didn't do anything wrong. He said we didn't do anything wrong, right? And then the sergeant says, yes, we did. We were supposed to protect people like him, and we didn't. And right. To me, that's the whole going against the organization. If they have a ritualistic hazing indoctrination or bullying indoctrination, or just allowing bullying because we think it's funny, you should be protecting our own people.
Yeah, good point.
All right, let's go to Arizona. Also really interesting and really confusing. So here we have an Arizona firefighter. He claims that he was terminated for reporting illegal conduct. Now, I want to start this by saying I watch Fire Country, and this reminds me of the TV show Fire Country, because and if you don't watch it, I'm not suggesting you do or don't, but this is exactly what happens in a number of the episodes. So here we have a firefighter who I think is a supervisor, but alleged, and this is the Fire Country program. This is the Department of Justice or DOCS or whatever puts prisoners right into the Department of Forestry and Fire Management, and they become kind of workers and firefighters. So here, this a firefighter reported, and I don't understand the age discrimination, we'll get to that, but reported basically that some of these individuals are using spice, which I guess is a synthetic marijuana type product, but it's illegal, certainly. And he reported allegedly that some crew members were involved in dealing and drug dealing.
Let me just fill you in on the age and some of the other things. So it'll help it make more sense. He was in charge of this corrections firefighting unit. So he was a career employee with the Arizona Department of Forestry, and he's supervising this crew of criminals. And he gets a deployment order, and he says, "We're not going." Okay. And they said, "What do you mean you're not going?" And he said, "Here's why we're not going." And then his employer, or one of his supervisors, apparently said, or at least according to him, apparently threatened him with being replaced with a younger supervisor.
Wow.
and he was advised not to make a formal allegation about this, and I guess not make it a big deal. He pressed it. He pressed the issue. That's the allegation. Now,
and these are all just allegations, right?
I would imagine the state has an entirely different take on why this guy didn't want to deploy on that particular day, and it may go to some other issues. But at least as far as the complaint goes, that's the allegation. And
he works some other stuff in, right? He works disability in. He misses an issue about which we'll talk about, but he works disability in, saying the stress and all this, and these harassments, whatever, it triggers a migraine. So now he's got potentially an Americans with Disabilities issue, which he's alleging.
There's another issue beneath the surface here that you may, all right.
That's where I'm going. I'll get there in a minute.
I want to make sure you got it.
And I read the complaint just to make sure they didn't allege it. Where Kurt and I are going, our Family and Medical Leave Act, we'll talk about that. It's not alleged in any event. So we have the age issue, we have a discrimination issue, we have a whistleblowing issue where he alleges, and I think I'm going to cut out here because we just froze.
Oh.
So I'm going to take a moment and pause as I get kicked off and come back on. Hopefully, I'll be back momentarily.
All right. So while Brad is
I'm back.
Oh, there we go. Wow, that was
quick. All right. So this happens. I apologize when I'm home. I get kicked off every so often. So I don't know where we are. I saw you lost me, but so we have the age discrimination allegation, which, by the way, went through a process where they found reasonable cause. The state commission found reasonable cause to support an age discrimination case. But and it's weird. I guess they only dealt with the age discrimination case, but he's also got a whistleblower case saying, well, I turned the department in about the drug issue. He's got the disability, the ADA disability case, which doesn't have to go through the state process. And the one he misses here, as we were talking about, is the Family and Medical Leave Act, which said he needed time off, etc. He could have raised FMLA retaliation discrimination for, hey, I have a disability or I have a medical condition. I needed time off. You refused to give it to me. You fired me. So they had a bunch of them. I will also say, look, this is just allegations. I don't know that we need to say more. You're 100% right? The state's going to come in and have a totally different story. This guy's, and I'm making this up for everybody, right? They could allege this guy's been a problem employee and we did investigate, but the complaint alleges all of these things. And I don't love how the complaint's written. They put the bases for the complaint for the lawsuit in a heading, and you shouldn't do that. Headings aren't admissible necessarily as part of the body of your complaint, but nonetheless, what they do is they outline all in the heading. Okay, we're age discrimination in the heading, and whistleblowing in the heading, not in the basis. But the reason I bring that up is because their first allegation is age. And I was a little confused why would you go with age when it seems like reporting the drug issue is a bigger one and might have, right? And the medical may be bigger. Why are we going on age? Because most of this seems retaliatory and age is just a, minor part of it. They just brought it up or whatever. But in any event, I think the reason he raises age is because they've already got a state entity, right, saying reasonable, that's a reasonable claim, and gives them the right to sue letter, and says,
I think the whistleblower is a state law whistleblower. There's no federal whistleblower that he's alleging, and he's in federal court. So in order to stay in federal court, he's alleging the ADA
as the primary. That makes some more sense.
I think that would be one explanation for it.
Yeah, and I would surprise say you would think with yes, federal. I assume this is all state criminals, but they're on land. I don't know. I could see a way to work in some federal stuff possibly, but nonetheless, there they are. So it's an interesting claim. We're going to see how that works out. And you're right. The state's going to come in with a whole different story.
Oh, absolutely. But I will tell you, this guy's he almost immediately apparently got a job with the Pine Top Fire District, who's one of my I feel like a closeness. I've been to Pine Top a couple of times. I love the area. It's just a beautiful, absolutely beautiful part of Arizona. Arizona is such a beautiful state to begin with, but it's just absolutely beautiful up there. But he got picked up almost immediately by the Pine Top Fire District. And they do a lot of wildland firefighting. I was actually funny. I was in California visiting my son, and we stopped in to get a sandwich at a restaurant, and two Pine Top fire trucks pull in, and I'm going, are you guys from Pine Top, California? No, we're from Pine Top, Arizona. We're deploying up to a fire upstate.
wow.
So yeah, so they've got they're very, very well known for being a good wildland fire department.
And
So,
in of course, LA, you mentioned California, LA on Saturday, yesterday had that huge fire under the bridge, under a highway, and the highways melted steel, but they had
really?
116 or so firefighters. It was a big deal.
Oh,
That
I
was
missed.
going, that was
I'm traveling. For those of you, if you haven't figured it out, my hair's a mess. I'm exhausted. I'm out on the West Coast and doing some training out here. So
yeah, you
I'm a
missed the
little
big news.
discombobulated.
That's okay. My wife sent it to me. So she's like, hey, did you see this? So it's always good when your wife is feeding you the media.
Yeah.
Let's end today. This is gonna be a great discussion.
Yeah.
I don't know if you want to do the facts, you want me to do it, but let's go to Boston.
I'll do it. I'll do it. I'll do it. Only because I've been following this case now since 2018, and I have some sympathy for the firefighter involved, but I also am very familiar with the law, and I just don't see how he gets himself out of this situation. But we got an African American firefighter who's also the vice president of the Boston Vulcan Society, Boston Firefighter Vulcan Society, which is an organization of African American or minority firefighters in Boston. And he apparently was turned in for an inappropriate post. There was something that he posted, which the reason I say that it's interesting because the original post that he was reported, I think, is protected by the First Amendment. It was a post. It had to do with Nat Turner's slave rebellion, and again, he's the vice president of the Vulcan Society, and arguably it was offensive. But I think, all in all, I think it was probably close. It was a close call. Depends on what the judge is going to say, which is my beef with Pickering.
Right.
Okay, but at any rate,
we'll get there.
So, but that's what starts the investigation. Once the investigation gets going, though, they find this whole mess of just really horrific offensive posts. And I don't want to get into it. I've got you. If you want to go back on my blog and go read all the things.
Racially charged.
Yeah, racially and homophobic and misogynistic and a whole bunch of others. So,
not the light you would want a member of your department depicted, right? To build a public trust. And I say that for a reason.
Right. And I think part of his defense is that, hey, you started investigating me for something that's protected. And then it was only because of that you found these other things. But at the end of the day, you still posted those things. And even though they were posted as a private citizen, they weren't posted as a member of the Boston Fire Department. They were just so offensive that the department terminated him. And he challenged it through the mass civil service system. And I think a very well-reasoned decision, the Civil Service Commission upheld his termination. And I've got a link to that in there. And they did a pretty good job for not being a federal court and dealing with a difficult First Amendment issue. And certainly they are attorneys. But they did a pretty good job of addressing the First Amendment issue. Then it got into court, and we had a Superior Court decision, which essentially did a pretty good job of agreeing with the Civil Service Commission's analysis. And now we're at the Massachusetts Court of Appeals. And the Court of Appeals essentially did a very good overview of the First Amendment and concurred with both the Civil Service Commission and the trial court that we can't have public employees who are, it's not that you're expressing, it's not that it's your speech, it's that you believe these things. It's inconsistent with your willingness and ability to provide a service to everyone in the community. If you harbor this much animosity toward other people, you're not an appropriate fit to work in a public position. And I think that's at the heart of it. So yes, it is a free speech issue, certainly, but it goes beyond that. And the reason I say that is that's why, even though he did it as a private citizen, and it's certainly race relations and gender and all that certainly are matters of public concern.
Right. Everyone agreed to the first two parts, right?
Right. But it can cause actual harm or disruption to the mission and function of your employer. you know, we can't have Nazis, right? We can't have Nazis being firefighters or police officers. We can't. Do you have a First Amendment right to be a Nazi? Absolutely, absolutely. Okay, but we can't have someone who harbors that kind of hatred toward others working in a public capacity.
And, look, I'm Jewish, right? So right off the bat, I don't think we should have Nazis in the public service. But that
But
said,
you would defend if a Nazi came to you and was being unfairly targeted, you would defend them, And I'm not a fan of Nazis. Okay, well maybe you may,
especially Illinois Nazis.
Alan Dershowitz would. He said
Alan
repeatedly. You know what I'm saying? And that you say, despite the fact I vehemently disagree with you, I will defend you.
Add the because, what Alan Dershowitz says, because if you believe the Constitution, you have to defend every part of the Constitution. If anyone hasn't read his book for the last 20, 30 years, unfortunately, his defenses of Trump have skewed his credibility a little bit. But he's a brilliant man, Harvard professor. But absolutely. Al Dershowitz rightly says, if you are going to be a defender of the Constitution, you defend it when it makes you sick. Right. Now, here's my problem, right? Yes, the whole Nazi thing obviously makes me sick. Right now we have the whole Hamas, Palestine, Israeli, right? So it's a very tough time, and there are feelings that are being shared. But here's my problem. If I said to you, I don't like Jews because they're money hungry, whatever. Okay, so I don't like Jews. And by the way, anyone quoting this, I'm Jewish. This is not like this is an example. However, does that mean that I'm not going to risk my life to rescue you? It doesn't. And that's my problem with this, is because I spew an ideology that may harm my fire department's perception in the public. And I'm going to give you a very real example on top of this. That doesn't mean that I shouldn't have the right to say certain things. Now, hateful, bullying, certain speech is not speech at all, the U.S. Supreme Court said. So it's not protected because it's not speech. And a lot of this hateful, racist speech isn't even defined as speech, right? Says U.S. Supreme Court. The problem here is when you're speaking on an issue that you believe in and the public may not like it, does that mean that you don't trust the public? So let's get a very real one here. Black Lives Matter and the Confederate flag, right, are two big issues where, and I get it, the African-American community probably wouldn't trust a fire department with a Confederate flag on it, right? Probably wouldn't. But that's not hate speech because it's not used to intimidate, says the U.S. Supreme Court. Hate speech is speech that's used to intimidate. It's not just a symbol. And so the problem is if I spew an ideology, I don't like Black Lives Matter organization because I don't trust their money, maybe you say, or how they handle the money, right? Or I don't like Trump because he spews whatever ideology. But it's still, you have the right to support or not support those organizations and speak about them. And just because the public may find that distasteful, does that unprotect your speech? Well, that's my problem with some of this.
I get it. And that's, I think, this is Octavius Rowe's argument. I think that's the crux of his argument. The other side of it is, and the way the Supreme Court has interpreted it, is when you engage in speech that can cause actual harm or disruption to the mission and functions of the fire department. So now, so you have this right to have this thought, absolutely. But the fire department's got to show that it disrupts the mission. And the way that they do that is if, for example, if I don't know what's a better example, but let's use the Nazi the Nazi. Sure. If I am Jewish and somebody gets sick in my house or my house catches fire, I'm going to be saying, do I want to call 911 and have the Nazis come? And take a risk that one of those Nazi firefighters is going to come, because then he's going to know I live here, and maybe he won't do anything while he's here, but maybe he'll come back and get me at a later date, or I don't even want to take a chance I'm going to try to deal with the problem myself. And in that way, it interferes with the mission and function of the fire department, because, and they've said that in several of the decisions in this line of cases, is that the public, when they call 911, should be free to expect that the people who are going to come to help them are not going to harbor these kinds of hatred directed at them. And that we don't want people hesitating to call. Okay, same thing with the Confederate flag. And while on one side, I understand the symbolism for the South and folks, you know, it's a symbolism for white folks in the South of their ancestry and all that. But on the other hand, if you have Confederate flags hanging off the back of a fire truck, African Americans are going to be like, I don't want them coming to my house. And that's understandable. It interferes with the mission and function of the fire department. And that's the line. And is it a comfortable line? It's not a comfortable line. It's not a blurry line. It's a difficult line. Okay. Yeah. But again, just for our listeners, just to understand the Pickering decision, number one, it's got to be a matter of public concern. In order to have First Amendment protection, got to be a matter of public concern. You've got to do it as a private citizen. If you're in your uniform, if you're on duty, if you're doing it in a way that you're perceived as not doing it as a private citizen, you're not going to have protection. But matter of public concern as a private citizen, and then it can't cause actual harm and disruption to the mission and functions of the fire department. And we've got this balancing test that you know, actual harm or disruption is actually part of that balancing test that the courts have to look at.
And it's a like, very tough line. Like the balancing tests also have been used as like internal disruption, right? It causes disharmony and extreme disruption within the organization.
Right. So it's inside internal disruption, but also out external. So it's both of them. Yeah.
And I think it could be either or, right? I mean, if it either or both. And so in this case, sure, if somebody was and I was in the department, someone saying, oh, you know, we don't want a Jew as a chief. Right. Yeah. Well, that is language that, right, is A, not a matter of public concern, but B, it's disharmony, it's disruptive. The problem with that type of, and this is your issue, the problem with that type of balancing test, right, rights to free speech versus the effect and the disruption such a hard to define, right? So, well, 20% of our people are Jewish, and so they're pissed off. 80% of our community is Jewish, so they're pissed off. Or, you know, or, well, now nobody gets along. Or, you know, what is the amount of disruption necessary in the public or internal to cross the line?
Well, and that's where the judge's own personal bias can cause them to see disruption. You have one judge that on the same fact sees disruption. Another judge would say that's not disruption.
Right.
And there's an awful lot of discretion that a judge has in that. And the judges would say, oh, no, we don't have any discretion. You've got discretion. Okay. There's inevitably you're balancing. And that, you know, you and I, before we came on, you and I talked briefly about some of the differences that I have with our friend Chip Comstock, who I have the utmost respect for. Chip thinks the Pickering balancing test is a pretty good one. My reservation is that it gives judges too much discretion, and their personal bias, one way or the other, can cause a case to go. And we see that where a trial court says you're not protected, the intermediate appellate court says you are protected, and the Supreme Court says you're not. And the fact that you're going back and forth here means that, you know, we're in the weeds here when it comes to discretion.
Which is why my advice usually to my clients is, do you really want to go down that road? The problem here is, you know, now you have such a vocal, right, person that is, if you do nothing, it's going to make it look like you did nothing. Even if they lost the lawsuit, right? Even if the municipality is deemed, the fire department's deemed, okay, violated his First Amendment rights, I don't think it mattered. I think this was a lose-lose situation. If you didn't go after it, then in the public's eyes, you were tolerating it. And let the public be mad here at the court system if they had held it wasn't protected, right? Here it turned out to be a win for the fire department. But I don't think the fire department had a choice. But normally my advice to my clients is, and I'm a pretty aggressive lawyer when it comes to litigating, and, you know, but normally I'm suggesting, look, is it worth 5 years of a fight, which has a 50-50 flip of a coin chance at winning to fight free speech issues, or is it worth just letting it go? Right. Yeah. And grow a thick skin. Here, your community can't grow a thick skin when they're watching a firefighter do this, different issue, but still, these are tough to win and they're tough to predict, right? Yeah. As you said, you can't predict it.
Right. Yeah, it is. I mean, I equate it to, I've played baseball most of my life, and I've managed a lot of teams, coached and managed a lot of teams, and you're down a run and you got to run around first base. Do you have him steal? Do you not have him steal? You're not going to know whether he's going to be out or safe until he gets to second base. You can have a guess that I got a fast runner, I got a catcher with a bad arm. Maybe we got a good chance, but that's what you're dealing with here when it comes to posts on social media. Are you going to be out? You're going to be safe? I don't know. We'll see what the umpire says when you get to second base.
Right. I'll let you know you're brilliant if you were right.
Yeah. Right? There you go.
If no different, should we go for the 2 point, right? Or just just take the normal PAT, or should we go for 2 points and try to win it right here? You don't know, right? So, but I got to tell you, and I open this way, I'll close this way. These cases are great cases for so many different reasons, but all of them help expose issues that how the public will view you, whether it's the bullying, whether it's the drugs on the fire scene, whether it's the racist, homophobic comments, right? Whether it's all of these cases, whether it's the theft or misuse of public funds, all of these cases I found so exciting, and thank everyone for watching to the end, because it's all about how the public's going to view us. Right. And what we need to do to protect our image, because if we don't protect our image, then these are the images that are going to be seen. And it's going to result in loss of funding, loss of trust, loss of people wanting to work in your location. Right. People aren't going to come to work there if it's a bullying, harassing, whatever environment. These things aren't good for us. So all of these cases had one theme, which I thought was so interesting: public trust. No, great choice.
Right, well, that's going to do it for another edition of Fire Law Roundup. Thank you, everyone, for listening. If you like it, please click like and share, and we'll see you again next week. Brad, thank you very much.
Thank you.
We'll see you. We'll see you probably before next week. I'll be in touch, but